Good morning and welcome to Notre Dame Law School. My name is Nicholas DeAndre. I am Editor-in-Chief of the Notre Dame Law Review, and it's my pleasure to open today's Federal Court Symposium. Today's symposium is actually the third that the Law Review is doing in Volume 98. Our first one was on unconstitutional conditions and religious liberty, the second on liberalism, Christianity, and constitutionalism, and today is on the history and judicial review of the Administrative Procedure Act. The scholarship that you hear today will be forthcoming in our annual Federal Courts Practice and Procedure issue. And we are honored to welcome 9 esteemed authors from across the country to discuss their scholarship. I will ask you please to refrain from taking photos or videos during today's event, but it will be recorded and posted online shortly after the event. Today's topic, as I said, is on the Administrative Procedure Act, and one of the reasons that I am excited and my e-board was very excited to host today's symposium is because we got a proposal from Professor Bremer to organize and produce a symposium on this topic, and we were just thrilled to work with her as the chair for our symposium and are very excited to hear our scholarship, the scholarship that's discussed today. So I'm going to actually ask Professor Bremer to come up and talk about her collection a bit and the research that she has done on this topic and kick off our symposium for today. So please welcome Professor Bremer. Thanks.
Thank you and good morning. I'm going to keep this very brief, but I'm really delighted that the Law Review accepted my proposal to do a symposium on this topic. For the last several years, I have been researching the history of the Administrative Procedure Act. I spent most of the pandemic living between 1939 and 1947, which in the circumstances seemed like a respite. Reading all of the documents underlying the APA and writing several articles about its history, I was surprised to discover much that's very similar to the administrative state we know today, as well as many things that we've forgotten since 1946. So it's been a rich source of material for my tenure file. I also discovered, actually at another law review symposium, I was talking with Catherine Kovacs, who's a professor at Rutgers. She has also been working on the history of the Administrative Procedure Act for many years. And we got into a long conversation about how nice it would be if all that stuff was in one place, because it's not. Historically, it's been sort of scattered all over the place. And so we worked together with a librarian at Rutgers to convince Hein Online that they should do a collection of historic documents related to the APA, which is called the Bremer-Kovacs Collection. That's how we were paid for our work on the collection. That was the one thing we wanted, was our name on it, and we got that. And now you can go on Hein Online and get all of the legislative history, the bills starting in 1929. The collection begins with the very first bill to regulate administrative procedure in 1929 and ends with the Attorney General's Manual on the Administrative Procedure Act, which was published in 1947, and everything in between. And the APA's legislative history is a little weird because it's not just legislative documents, it's also executive documents, most notably really voluminous research by a committee called the Attorney General's Committee on Administrative Procedure, as well as a lot of documents from the American Bar Association, which was instrumental in pushing for APA reform. So we have all of those materials in the collection, and when you are done with today and listening to our wonderful speakers, you can go do some research of your own. And I want to thank all of our authors. The presentations just look fabulous. The papers are awesome. This is just such a wonderful collection of some of my favorite people who write on these subjects and in this space. And most importantly, I want to thank the student editors for putting together just a phenomenal program and running this as smoothly as you can possibly imagine. I mean, I gave them the proposal, but all of the work was entirely done by them, and I'm very grateful for it. So thank you, and I hope you enjoy today's conversation.
Thank you, and my name is Jake Tidmarsh. I'm a professor here at the law school, and let me extend as well my own welcome to all of you, and particularly to our first panel today, which will be discussing the history of the Administrative Procedure Act. So I guess many of the papers will do. These three papers are three wonderful papers. They kind of interlock with each other. So I think there's going to be a good opportunity for discussion. What we plan to do is that each of the three presenters will present their paper for about 15 minutes or so, and then maybe at that point have some interaction with each other because of the way in which these papers do interact. Then we'll open it up for any questions from the floor. So our three speakers today are, first of all, Kristin Hickman from the University of Minnesota, Chris Walker from Michigan, and John Ferejohn from NYU. So without any further ado, let's begin with John's paper.
Okay, thank you. Thanks very much for inviting me. Bill Eskridge, who's a co-author on this paper, and I wrote a book some years ago called Republic of Statutes, in which one of the reviews was by Adrian Vermeule, who complained that we didn't treat the APA as a super statute or as one of our cases, though we did talk about it, but incidentally to other statutes. And so, and I should just say to begin with, relevant to another paper that will be delivered this afternoon, almost all the cases in that book had to do with statutes we would call movement statutes. That's that arose from some kind of social movement or some kind of pressure from the outside of government that was substantively oriented towards some kind of morality that had to be, or that was in fact incorporated in the American state in the 20th century. And the APA is a peculiar kind of statute because it isn't that kind of statute. You know, it's a statute that, we'll talk about it in a minute, but it's what I think Kathy Kovich calls a framework statute. And a framework statute has this kind of structural quality. In other words, it provides some kind of legitimation for rulemaking and adjudication, but it doesn't do all the work of legitimation because that in turn is parasitic on what's being made rules about. You know, so on the legislation, on the constitutionality of the legislation, on the moral purposes for which it's dedicated. So it's a funny kind of statute, and it's really a great opportunity to have a chance to talk about it a little bit here and to have a chance to have thought about it. And sooner or later, Bill will come to believe what I believe, so. Maybe not. He never has so far, so. Anyway, so there's a landmark article that we started with by George Shepard, which I'm sure everybody who's studied this has looked at, and he depicts the APA as a fierce compromise between opponents of the New Deal, more or less intransigent opponents, and proponents who wanted to keep it up. And so it's formulated as something that arose at the end of the 30s, in which the legislative vehicle they ended up pushing, the Walter Logan bill, was passed in Congress, but that it was vetoed by Roosevelt. And Roosevelt had appointed a committee, which was just referred to by Emily, of the Attorney General at the time, whose name I now forget, but there was a series of Attorney Generals at that period. One of them, Francis Biddle, was on the committee that was appointed there. And so that committee did a lot of work in terms of evaluating how administrative agencies worked. I think there were something like 47 reports, I think. And so the report of that committee came out in 41, I think, after the defeat of the Walter Logan bill, and then there was a war. All right, so and I'll get back to the war in a minute. But the point was, there had been a fierce conflict in the late 30s about the Walter Logan bill and the antecedents to it, and you might have thought that would have continued through the war, and that would have been the grounds for the compromise that Shepard describes as a fierce compromise. But that's not actually what happened, in my view. And I'll be delighted to hear others who know more about the history than I do. But what I think happened is actually there was a purge of the major opponent organization against the New Deal administration, which was the APA, American Bar Association. That was led initially at that point by the committee was led by proponents of Roscoe Pound, who by then was an opponent of many New Deal practices, and Colonel McGuire, who was, I think, either the head of the committee or the chief, the guy who did all the work, as far as I know. Anyway, those guys were purged, and so what happened was they were replaced in 40 and 41 by, I think, Carl McFarland and others who were there were New Dealers. There were, McFarland came over from the Justice Department, and so the committee they set up to, was a committee that had a number of people who ended up being New Deal lawyers and university presidents and others like Arthur Vanderbilt and others. So that committee was a committee that almost everybody, accepted all of the main principles that were embodied later on in the APA, and they were negotiating with themselves in effect. So that what happened was there was a consensus that was built, prior to 1946. And we depict what happened was not a fierce compromise, but a deep compromise, a compromise that embodied two pivotal values that were fundamentally in tension, which is values having to do with democracy and values having to do with rule of law or due process. And all the parties, as far as we can tell, after the purge, were pretty much on the same page about what shape that should take. And so the range of plausible alternatives was, in the final bills that before the APA in 1946 was pretty narrow. So especially on the rulemaking aspects, it was narrow because what was agreed to were rules which were already understood widely as perfections of what were more or less best practices of agencies already. So there wasn't a big change in the rulemaking front. I guess there was a much bigger, so what the APA accomplished at that point was to regularize rulemaking across many agencies. There were some notable exceptions in defense and some other places, but mostly it standardized what was best practice across agencies in the rulemaking aspect. And I guess that was a much harder slog in adjudication. People will talk about that later, but at least with respect to rulemaking, I think that was the accomplishment, and I think it was acceptable because it was a deep compromise. And the model for that idea of deep compromise is really drawn from two places. One was from John Rawls's conception of public reason or overlapping consensus. The other was developed further by his student from a different point of view, Henry Richardson, who's at Georgetown, I guess, a philosopher. In a book I think he calls it Democratic Autonomy, which very usefully describes what we think about as a process by which deep compromises comes about. His focus is on disability legislation and how it got implemented in gradually over the early 70s. But the process was similar, which was it was a process in which there were wide gulfs in the beginning between pretty deeply opposed points of view, in which the 2 points of view couldn't really understand each other very well, and gradually over a period of 4 or 5 years, with some congressional intervention, but more the intervention of General Counsel of the Transportation Agency, there was a formation of a basis on which everybody could agree to move forward in ways that was acceptable more or less to the transport industries, et cetera. So, and to the different interest groups like the disabled and the aged who had to live under these new regimes. So that was that's the kind of model we're using here. And so we think the APA was more like that, at least on the rulemaking side, than it was on a fierce compromise. So the story we're telling is the APA was formed at this deep compromise between these two values which are in tension, that is rule of law and democracy. Both of them are open-ended ideas. It's not, there are many different conceptions of democracy. They're in dispute. You can see in some of the papers in the symposium today. They're in dispute among the authors here. Some of them are excoriated as, pluralist democracy, in which there's a picture of bargaining and log rolling, in which people don't actually agree with each other, and others are more of a Republican model, associated nowadays with people like Philip Pettit and others. But still, there's even those like Pettit, are going to recognize the centrality of diversity and plurality in other ways. So this is a complicated area of the democracy side, and of course, law itself is conceptually a difficult concept, and it's the subject of a large part of the legal curriculum in some law schools, in legal theory. So all these issues are in dispute, and so when there's an attempt to resolve disputes between these values, which are fundamentally in tension, it seems to me, there's a lot of wiggle room in terms of different conceptions, and there's a lot of re-theorizing that goes on, among the disputants and also among in the public sphere, in academia, et cetera. So we think it helps to think that way, to think about the APA in that way, because it may throw some light on some of the issues that are around today, which is, for example, how should we understand the APA as it was developed in 1946 as in some sense fixed in place and something that ought not to be revised easily, which I agree with, not easily, but revised at all. And I would say that personally, that I think the APA was a compromise, and like all compromises, things got left off the table at the end of the day, and so it was imperfect in many ways, and one person's imperfection is another person's flaw, so that's the nature of an imperfect piece of legislation. And so, I would say that it seems plausible to think that there might be parts of the APA that might be understood as relatively fixed. One very central part in the rulemaking notion was the idea of consultation or informal as opposed to formal rulemaking. That seems extremely central. So it seemed to me that attempts, whether judicial or otherwise, to burden rulemaking with formal procedures ought to be looked at suspiciously. And there were attempts both legislatively and there have been attempts judicially to do both. The Bumpers amendments that occurred in the late 70s, I guess, and early 80s that were successfully revised in a more moderate direction, but still all failed, were efforts to do exactly that. So, and of course there are well-known judicial rulings which put a limit to how much formality can be imposed on these proceedings. But still, it seems to me that it's plausible to take the APA as setting a pretty firm ceiling on procedure in the rulemaking domain. On the other hand, it seems like some kinds of things that were imperfect in the APA were that there wasn't much of a record requirement in the APA, and there wasn't much for the judges to review in terms of process initially. And it seems to me that reforms that are aimed to improve the record, to make it possible for the part of the compromise that had to do with the agencies being subject to judicial review should be improved. And so I think those kinds of compromises, whether done legislatively or judicially, are welcome, should be welcome. But the way in which they should happen, it seems to be, should be guided by the values that we talked about at the beginning. That is, they should be guided by serving the fundamental values that are underlying the APA itself, namely values of democracy and rule of law, recognizing the complexity of those values on the ground. So it seems to me that with respect to one of the issues that's going to come up here today is, should the APA be developed in a common law way in courts? I would say, at least in part, there should be some openness to common law improvements of the APA. On the other hand, some parts of it ought to be taken as relatively fixed. But in both cases, it seems to me that the fundamental values underlying what we call the compromise ought to be respected in either refusing to update the APA or in updating it where it seems appropriate. So that's sort of the line of the paper we take. There's a lot of words that go with it, but those are the ones I'm going to give you right now. Thank you.
Very good. Chris?
Awesome. Well, this is so much fun, especially to have Ferejohn and Bill's paper that, we've been talking about whether the APA is a super statute without them in the conversation for a while now. It's good to have them jump in and kind of tell us whether we're wrong or right, and it sounds like we're kind of wrong and right, which is always fun. And then it's also always great to be on a panel with Kristin, who's one of the most prominent administrative law scholars out there and knows the APA as well as anyone. So my essay with my co-author Scott is just trying to kind of pause and take a look at the state of the play and provide a literature review of where are we at with APA interpretation. There's been hundreds of articles written. And so we try in the article to divide things out into kind of three categories or modes or theories of APA interpretation. And I think it works, although I'd love for those here to let me know if it doesn't work. Or also, we're still searching for the right names for a couple of them. I'm not sure they quite fit. But so if I were telling the story, I think the historically predominant approach would be what we call APA pragmatism, which I'm kind of going back for that now. In other words, more of a textually constrained purposivism. So we take the text of the APA, we're trying to make it work, things are changing, but ultimately we're still kind of trying to kind of hew to the text of the APA as kind of what we're doing. But there will be a little bit of additions here and there. When the Supreme Court basically got rid of formal rulemaking, you see courts kind of respond and add more process and informal rulemaking. I think that's one example that I at least put in the category of APA pragmatism or this kind of textually constrained purposivism. Now that, if you take that to the next level, you get what Jillian Metzger has called administrative common law making. In other words, this is how the argument goes, not the one that John provided today, but the normal superstatute argument goes is that the APA is a superstatute. It was an invitation for courts and agencies to innovate, and they should do it in a common law method and adopt additional things that don't really have anything to do with the text of the APA that further advance those kind of values that we have, rule of law values, democracy values, and administrative law. Some have gone so far as Jillian and John Michaels and others to argue that not only are these doctrines like good, but they're constitutionally obligated, which is a kind of a more extreme version of that. The next kind of response to that movement, I call it a response, and I'll say all four of these theories are alive today, and in fact I'd say even the Supreme Court, the majority of the Supreme Court has adopted all four in various cases, is the APA textualism movement. I think Vermont Yankee really captures this. Just let's go back to the text. Anything that's beyond the text, courts, you can't add. Agencies have a space, as Emily Bremer and Sarah Jacobs say, a space to kind of innovate, a white space to innovate, but courts have to really kind of just enforce the bare minimums. Not surprisingly, that tracks well with the rise of textualism and statutory interpretation generally. And also not surprisingly, in the last few years, you've seen a fourth kind of variant of that, which we call APA originalism. So in other words, it's a more kind of common meaning, trying to understand what the words meant at the time the APA was enacted, as opposed to just kind of taking a more, what Kristin in her paper calls literalist, what Tara Lee Grove calls in her scholarship more formalist textualism. This is kind of a richer, deeper, more historical version of textualism. So we kind of just take all literature and the cases that have come out and just kind of try to put them into those four buckets. As Ron Levin's mentioned some of his prior work, the line drawing's not easy, and we probably draw the wrong lines here and there. That's really not the thrust. The thrust is more to kind of identify that there are four, I think, distinct flavors or moves or theories of interpreting the APA. Now I want to engage a little bit more with John and Bill's newest paper here and talk about administrative common law making. And I think, John, I don't disagree as much as I thought we would. I don't view the APA as a super statute in the sense of the Ferejohn Esseridge model. I don't think it's an invitation to engage in administrative common law making. I don't think it's an open-ended statute that's inviting. And I think at least John agrees with me some of that. But I view it much more as a compromise that set the default ground rules that regularized some best practices in administrative law. So I kind of think of it more as a framework statute. Definitely incorporates some quasi-constitutional values, rule of law values, and democracy values, as John mentioned. But in that sense, I don't think it provides a fertile ground for administrative common law making. In fact, I think it does the opposite, as opposed to some of the other maybe movement statutes that John has mentioned in the book. And one reason I don't is I view the APA as setting the default standards that can be overridden. And it turns out that Congress has overridden those default standards in so many different contexts. They've been very active when it comes to administrative procedures. And Jill Family's piece we'll hear about later today is a really great deep dive in the immigration context, where Congress has come in and passed statutes and really created a whole framework that's very different than the APA when it comes to judicial review, when it comes to agency adjudication. And in fact, as Emily Bremer has mentioned, a lot of her work, there's not, when it comes to adjudication, a standard story. You have to look at the statutes and regulations that govern each adjudication, and you see just a real variety of procedures, of standards of review, of processes. And I say that because if it's a super statute that we think common law should, I don't usually think of a common law statute as one where Congress is regularly tinkering with the rules as well. Right? So that's kind of something I think, if you're making an argument that it's a common law statute, which I think Katie Kovacs is making more than John and Bill, at least in this paper, I think you have to grapple with that. And it's not just that, even in the rulemaking context, we see dramatic departures from what we think the APA should be. I mean, think of the high profile cases that made it to the Supreme Court in recent years. The census case, no rulemaking there. DACA rescission, no rulemaking there. The OSHA, the CDC. I mean, these are all kind of cases that are classic big regulatory cases. We're talking about major questions. And yet you don't have that kind of flavor of the APA really kind of guiding what's supposed to happen from a procedural perspective. The last thing I want to mention, and John didn't mention this in his presentation, is they've got a fascinating part in the paper about the major questions doctrine. And there's a really great attack on how it's not textualist. But it is administrative common law making. I mean, it's classic purposivism. It's the court is looking at it and trying to guess whether you think Congress was doing this. I'd actually love to see kind of more engagement of, is this not really what they're doing if we believe that the Administrative Procedure Act should be common law? It also reflects values of the rule of law and democracy. Justice Kagan would say it doesn't reflect the right values of it, but it's kind of grappling what the values are. And you think, when I think of the major questions doctrine, if it's a common law doctrine that has kind of grounding, I mean, it's two essential elements: no elephants and mouse holes, no using really old statutes to do things that we know that Congress likely didn't even know about, and the current Congress doesn't want to do. I think have a lot of resonance if we're in that administrative common law category of APA interpretation. Not surprisingly, I'm not there. I mean, and we end the paper with a little bit of like what Scott and I think and about how you should interpret the APA. And our take is kind of old, classic, boring judicial conservatism, which is if there's an open question of statutory interpretation, we think APA originalism is the best approach because it is a framework statute that's been entrenched, that's been, that's better than just kind of literalist textualism. I think I agree with everything Kristin says in his paper on that front. But the more boring part is, if the courts have answered the question, that's the pool of statutory stare decisis should be very strong. And let me kind of end with 3 points on that. The first is the reliance interests are deep when it comes to how how courts interpret the APA. Agencies, the regulated, even Congress, relies on those interpretations and they advance. The second, which I've already mentioned, is that Congress, even though they've only amended the APA probably fewer than 20 times in its history, over 75 years, or almost 75 years, they've amended so many other statutes. Hundreds and hundreds of statutes have departed from the APA or otherwise modified the APA when it comes to specific agencies. In other words, Congress is legislating against the backdrop of these rules, and these rules incorporate the judicial precedents. And the last part, and maybe we don't include it in the paper, although I think we should, is just this idea that it's not just about Supreme Court precedent that we should care about. That settled precedents among the lower courts should also get weight. And I know that doesn't fit into the normal stare decisis framework, and maybe stare decisis isn't the right way to think about that, but it's really important in light of the reliance interest and the fact that Congress is legislating against the backdrop of the APA comment, the interpretation that existed, that when the Supreme Court's looking at interpretations of the APA, practices that courts have blessed under interpreting the APA, that they think about that settled precedent. I'll end there just saying, we had the case, the oral argument of the case last couple weeks ago about universal vacature or nationwide injunctions, universal vacature of rules, which is a common practice in the DC Circuit for a long, long time, and Ron's gonna talk about this more in his paper. And I just loved at the end, Justice Kavanaugh was like, we've allowed the DC Circuit to do this forever. Shouldn't that be like evidence that should just continue? And kind of reflecting this idea that lower courts settle precedents. And then my favorite one, of course, Chief Justice Roberts is like, when I was on the DC Circuit, this happened 5 times before breakfast, right? And so I think when we're interpreting a statute like the APA, different than other statutes where a more textualist approach, may win the day, but a framework statute, a compromise statute like that, it's really, really important that the Supreme Court consider the settled practices among the lower courts.
Okay, I want to start off by thanking Emily and the students. This is a great symposium and I'm excited to be here. So the essay that I'm contributing here is co-authored with my sometime co-author, Mark Thompson, who wasn't able to be here today, but because he's in practice. But in any event, it seems to us that textualism and the APA are on a potential collision course before the Supreme Court that could fundamentally alter notice and comment rulemaking. We don't think it has to be that way. We think, even if you assume textualism as the interpretive methodology, that you don't necessarily have to get to the end of fundamentally altering notice and comment rulemaking. And that's essentially what we're dedicating this essay to talking about. So as has been mentioned, the APA was adopted in 1946, long before the rise of the new textualism. Like the Constitution, the APA reflects a lot of what Larry Solom would call underdeterminacy. So even though it has some terms that are quite specific, key provisions of the APA rely very heavily on undefined and open-textured terminology. I think this is what prompts us to use the terminology that John and Chris have been using to label the APA as a framework statute. Although there have been some Supreme Court cases interpreting the provisions that are relevant to notice and comment rulemaking, most of the case law does come from the circuit courts, as Chris mentions. And that case law didn't use textualist methods to interpret the APA. And because that case law comes from the circuit courts, it doesn't technically have any stare decisis binding effect on the Supreme Court, so the Supreme Court can come back, in theory, and reshape a lot of long-standing black-letter administrative law doctrine regarding notice and comment rulemaking procedure without overruling Supreme Court precedent. As we see it, though, a lot of that long-standing black-letter administrative law doctrine interpreting the APA can at least be reconciled with the APA's text. It just depends on which textualist methods you're willing to use, or to use Tara Lee Grove's terminology, which textualism. Textualism encompasses a range of views about how to approach text and which interpretive tools to use. Our argument here is that the APA is the sort of statute that requires a more contextualist textualism that looks at the interaction of different provisions of the statute with one another, rather than the more narrow literalism that we sometimes see from the court with respect to statutory interpretation these days. So let's go back to the underdeterminacy of the APA's terms. What does it mean for agency action to be arbitrary and capricious? What does it mean to give interested parties an opportunity to participate in a rulemaking? We talk about notice and comment rulemaking, but the actual statutory term is participation, which seems broader to me than simply submitting comments. Arbitrary and capricious are meaningless terms without context. In the State Farm case back in 1983, the Supreme Court suggested a series of questions that an agency needs to satisfy to demonstrate that its actions are reasonable and not arbitrary and capricious. Things like examining the relevant data, drawing a rational connection between factual findings and regulatory policy choices, considering the important aspects of a problem, and so on. In Overton Park, a case that was decided in the early 1970s, the Supreme Court acknowledged that if it was going to do its job in reviewing agency actions for arbitrariness, the agency needed to provide it with an adequate record to enable it to do that. None of this is spelled out explicitly in the terms of the APA. It also doesn't really draw from legislative history, or necessarily rely on purpose over text. Rather, it gives common sense meaning to underdetermined statutory terms, arbitrary and capricious. So now let's put that together with Section 553 of the APA. Here we have lots of doctrines that, again, aren't specified in the APA's text. Logical outgrowth, responding to significant comments, requiring agencies to articulate at the notice stage the scientific or technical studies on which they rely. If you look at sections 553B and C of the APA in isolation, and quite literally, you get rid of all of these doctrines that have been around since the late 1970s and early 1980s. But then what are you left with? How do you know that the agency has considered all of the relevant information? How do you know if the agency has failed to consider the important aspects of the problem? How do you satisfy State Farm if you get rid of these doctrines that interpret 553B and C? There's a symbiotic relationship between 706-2A, the arbitrary and capricious standard, and 553B and C governing rulemaking. And the doctrines that the circuit courts have adopted give meaning to words in Section 553 like participation and after consideration of the relevant matter presented, while facilitating judicial review under the arbitrary and capricious standards. The doctrines in question may have been defended at the time, and indeed they still are defended based on goals like transparency, accountability, democratic legitimacy, due process, etc. But they're also defensible as simply giving content to text in the APA that on its own doesn't have precise meaning. Let me just say normatively for a moment that I know that people complain about how onerous notice and comment rulemaking has become and how the perceived excess of procedure gets in the way of agencies accomplishing regulatory goals. But let me make a few observations here. Number one, we got to where we are now with respect to APA interpretation and notice and comment rulemaking only after the Supreme Court more or less wiped formal rulemaking off the map with Florida East Coast Railway. No matter how much we have layered onto notice and comment rulemaking procedurally, it's still less onerous than formal rulemaking with oral evidentiary hearings. It's also still more efficient than legislation, simply because the multiplicity of agencies can do more than Congress can do alone, even if rulemaking takes a while to accomplish. Finally, most rulemakings don't actually take that long and don't have ridiculously long preambles, et cetera. There's sort of two different sets of rulemakings if you really dig into what's going on. You have the occasional really, really big rulemaking. Think the Clean Power Plan or, net neutrality, those kinds of things, where the notice and comment rulemaking process is voluminous, huge, takes forever, right? You end up with your 500-page preambles. But then you have a lot of rulemakings that are just sort of mundane, everyday kinds of things that, end up not taking that long, 9 months, a year, maybe 18 months. You don't have ridiculously long preambles. You may be talking 20 pages. There's been empirical analysis showing that I think our perceptions of the onerousness of the notice and comment rulemaking process is driven by a small number of really big rulemakings that have sort of those features. But that's not most rulemakings. So I think when we, think about what we're doing with respect to the notice and comment rulemaking process and whether it's respecting circuit court decisions because of reliance interests or what have you, we really need to think about, do we really want to throw out all this baby with the bathwater? In the name of a textualism that I'm not sure necessarily even requires us to make these kinds of changes. Anyway, I'll leave it at that. There's a lot more in the paper and I'm happy to talk about it, but I'd like to get the conversation.
Wonderful, thanks to all three of you. I don't know if any of you have reactions to each other's papers that you'd like to share? No?
Well, I have a question for Kristin, just to begin with.
Yeah.
I haven't thought about this the way you have, but when the example you gave, net neutrality, I think maybe the benzene standard might be another long rulemaking.
Sure.
these rulemakings are marked by the fact, they're both extremely controversial. And they're extremely controversial among really big players, who have much to lose.
Right.
While I embrace informal rulemaking, no discount rulemaking, I recognize, of course, that naturally who's going to dominate the record are parties with interests, right? And when you have big players who have huge stakes, who disagree, then it's a good thing to have a long rulemaking. In other words, it says there is no consensus on this issue yet. Why would you expect rulemaking to be any easier than legislation? So it strikes me that it's not necessarily a criticism of the onerousness. If it's onerous of the onerous of informal rulemaking, if it's onerous when it should be onerous. Otherwise you get a coup. I remember that, at the end of the Obama administration, wasn't there a snowmobile rule or something like that about the permissiveness of whether snowmobiles are being permitted in national parks? And Obama didn't get it, or not, it wasn't Obama, it was the Clinton administration. And then Clinton didn't get the rule done fast enough, so there would have been, it was probably pretty fast, but they didn't think of it soon, And then, so Bush comes in and he gets rid of the rule, so it was short, there was no consensus there. The snowmobilers wanted one thing, the national park people wanted something else. It should have been more onerous there, it seems to me. It wasn't a good thing that he could slide one through. And of course, the incoming administration just reversed it because it wasn't settled yet. So I don't really see onerousness as necessarily a problem. In fact, I think it's an improvement over what is the most prominent defect of informal rulemaking, which is dominance of big players or affected interests, which, in the limit is not very democratic. It means people, and that's why, at least there were some congressional interventions that pointed to improving that aspect of rulemaking by inventing intervener processes or other things that would balance the ledger in terms of who would be in the record and who wouldn't be. So it strikes me that the defect from a democratic point of view is, it should be onerous if it's controversial, very controversial, deeply so. And speed is not necessarily a virtue, especially when it's kind of essentially a capture, And so I think those things are, it seems to me anyway, I don't know what you think about that, but
You're preaching to the choir here. I agree with you completely. I'm sort of
I'll talk to him.
I'm sort of echoing, I'm more in the last bit, the normative bit of what I had to say. I was more responding to concerns that I have heard, in the sort of normative side of the complaints about all of these interpretations of 553 and 553B and C that the lower courts have adopted, requiring response to significant comments, requiring the disclosure of studies, et cetera, that they've burdened the rulemaking process to make it essentially non-functional. And I don't think that's right. In making those arguments, people will point to the big rulemakings. It takes too long to get these things done. And my take on it is exactly the same as yours. Those are precisely the rulemakings that we would want to have take a long time and where we would want the kind of documentation that has been required. I will readily concede that my own empirical analysis is with respect to tax regs, which are, sort of their own creature in some ways. But one of the things that's interested me in looking at tax regs, and from what I've seen, other agencies are similar, you have a few outliers that are really big, take a long time, really do generate that kind of controversy, and where you want, from a normative standpoint, exactly the kind of engagement and disclosure, transparency that we're talking about. But there are so many little rules where you get very few comments.
Right.
Most people don't care that much. You get some explanation in the preamble, and there may be some discussion of comments received. And so, it's sort of like, well, it doesn't seem to me that, we blow out of proportion, I think, by virtue of looking at those big rulemakings, the burdens that the courts in interpreting the APA have placed on agencies. But again, that's sort of the normative take. I'm not sure if I'm going to throw it into the paper or not, because the paper really is intended to focus purely on the interpretation aspect. Plus I have a word limit,
I don't
but
think we do, actually.
I think I ignored it, whatever it was.
mine's already a little on the long side. But in any event, the bottom line ends up being, that's my normative position. But, to the extent that, your normative position may differ, at a minimum, I don't think the text of the APA requires you to go in a different direction. Simply because the APA doesn't use words like logical outgrowth or respond to significant comments. I think the text of the APA is both sufficiently underdeterminate and also sufficiently capacious. Much like a lot of the language in the Constitution, which we don't seem to have a problem using textualist methodology to interpret.
So I like this question, this area. I don't think we go there, but this is one area where the APA, at least after Florida East Coast Railway, we have a very flat view of rulemaking. And I think your intuition's one that a lot of us share. That maybe rulemaking requirements should differ depending on how important the rule is, or on how controversial it is. And that's something that when I worked for Senator Portman and Senator Hatch in a bill that Ron Levin loves, the Regulatory Accountability Act, we try to capture part of that. If you're going to do $1 billion rule, you might have to have an oral hearing. One, you really probably shouldn't be doing many $1 billion rules. If it's a $100 million rule, maybe you have to do one. I wish that act also said if it's a $100 rule, you shouldn't have to do any of that. We should return to a more informal rulemaking that doesn't have everything there. But I think there's some intuition about the more major it is. Instead, what you see happen is the court has come in, the courts, and kind of grafted on. All the different doctrines that Kristin mentioned are actually ratchets. The more important the rule is, the more you have to respond. The more comments you get, the more work you have to do. So in a lot of ways, the court has kind of recalibrated that. Whereas if it's not as controversial, if you're not changing your position, if there aren't great, you don't have to do as much. And I think the court's last move, the major questions doctrine, is in line with that. It's the next one of saying, all right, Congress cares about big rules. We have the Congressional Review Act that makes it harder for a president to cram through major rules at the end of an administration. And the independent agencies do it any time. And now we're going to kind of take our own take at this and say, if it's major, we're going to require Congress to be much more explicit that they meant for the agency to regulate in that way. And so I don't know, I think courts have stepped in and done that. Again, my old boring, we should allow the settled interpretations to settle, but probably shouldn't innovate now. But I do think Congress is one area where I've argued in other work that Congress really should come in and try to stratify out based on how important the rule is.
Well, and the historians may know this better than I do, but my sense is your $1 billion rules used to be done through formal rulemaking, which required oral evidentiary hearings, required, the development of a formal administrative record that included both oral and written testimony, had cross-examination of witnesses, had all of this kind of stuff. And we threw it out based on a pretty narrow literal interpretation of 553C, with Florida East Coast Railway. All of these other doctrines got adopted after that. And Vermont Yankee does provide a textualist limit. You can't just adopt everything. Like, for example, you can't impose oral evidentiary hearings. Because there's nothing you can really read into 553B and C that would allow you to import oral hearings necessarily, especially since 553 is so specific about participation through the submission of written, materials. But, I think you're right in saying that we do have what is effectively a ratchet. If you don't get a lot of comments, your rulemaking, and if your rulemaking is relatively small, the process is a lot less onerous than your $1 billion ones that are controversial.
So let me ask a question about, this is directly to Chris, but it's on the same subject, which is, and I don't care about the nomenclature, but he says that the APA is not rightly seen as a super statute because Congress has been involved by, for example, imposing other requirements on some specific agencies, let's say, that's what you're pointing to. In our book, actually, one of the marks of a super statute, we give multiple definitions, which is confusing, but one of them was congressional revisiting. So congressional revisiting for us is not the mark of the absence of a super statute, it's a mark that there is one. So in other words, it's exactly, insofar as the APA acts as a structuring device in directing Congress to how to amend a substantive statute, and that things are done in those terms, it seems like that's exhibiting that the APA is demonstrating a kind of what we call the gravitational effect on other statutes, including the substantive statutes. So that's not so much of a problem for us. But where this points for the earlier discussion is this: when you have a controversial rule, one possibility is to deal with it within the structure of the administrative state by doing what you talked about, Chris, which is saying if it's $1 billion rule, maybe it should have, well, let's say $1 trillion nowadays, billion here, $1 billion there. It's not real money yet, so when it gets to be real money, then you say, okay, impose a form of requirements. We would be resistant to that. I would say, why not think about it this way? That when you get a rulemaking started and it turns out to be deeply controversial, one of the things that happens is it gets really public, and you get more intense deliberation in the public sphere with many other interests that would otherwise be manifested on the record, at least on a record of the kind that's built in a normal rulemaking proceeding, or even an abnormal rulemaking proceeding. So all kinds of interests get formulated and formed and begin lobbying not just the agency in notes and comments, but also lobbying Congress and others to intervene. And so it seems to me that what happens in big rules is and ought to be somewhat endogenous. It shouldn't necessarily be structured by, prior straitjackets. There's like $1 billion test or $1 trillion test. It seems to me that when you get a controversial rule, it's a virtue, a democratic virtue, that the public sphere opens up to the issue, that many interests get formed. That's what democracy works like in a diverse world. So I think that's to be welcomed. And if it sticks in the inbox for a long time, well, that's where it kind of belongs for a long time. And I don't think there's an easy way out of that. We live in a complicated society, so things aren't always easy. So I would say I would be opposed to putting restrictions on major questions doctrine on those grounds. I have other grounds for opposing it too. One of which is I think we have a too flat a view of Congress and the congressional process. To me, one way to look at Congress is that it's designed from before America was a democracy, by the Minnesotanian period, to be very hard to work. It retained that feature after America democratized. So now we're a much more democratic country, and Congress is still hard to work, which means that you don't expect to have major legislative achievements very often. And there are extraordinary events in our history. And when they do happen, when some major event happens, like the Civil Rights Act of '64, I would say the Pregnancy Discrimination Act. You could name the ones in our book. Those are achievements, and there's a reason why we call them super statutes, because they structure debate both inside Congress, inside agencies, in the public sphere. And I think that's how they manifest themselves in this way. And I think the APA has some of that feature, that is, it does structure for the debates. It seems to be stable when you would not expect it to be stable if it's a mere fierce compromise. Congress has changed enormously at different periods, and it hasn't fundamentally undermined the rulemaking aspects of the APA. I agree on adjudication, it has changed it, like in immigration, changed it hugely, but I don't think it has in the rulemaking aspect in any really substantial way. It's in many ways what's happened both congressionally and judicially, I think, are often, like in State Farm, improvements from various points of view. So I would be reluctant about imposing additional requirements on the other aspect of democracy, which is the capacity of Congress, which is hard to organize, hard to coordinate. When it achieves a major legislative accomplishment, that should be free. We should leave it to play out in the agencies and the courts and in the public sphere to see what that accomplishment does. And imposing an additional requirement like someone's idea of what a major question is, I think that's stunts that process in a way that I don't think is a good idea. So anyway.
I think I like the major questions doctrine a little more than you do, as an outer boundary.
Or easy.
Do what?
That would be easy.
I mean, to me, the major questions doctrine is just, it's an outer boundary. In terms of, fine, we can delegate a lot of power to agencies to do a lot of things. And notably in West Virginia versus EPA, I think it's important to recognize that Congress, or the court doesn't say that Congress can't delegate power to an agency to resolve a major question. It says Congress didn't obviously delegate that power. And so, as a consequence, it's just a clear statement rule. And I think, to me, I'm okay with that. At least also, I suppose, because in some sense, I'm a little bit, for reasons as Chris suggests, in terms of old-fashioned judicial conservatism, the idea of resurrecting the non-delegation doctrine kind of makes me a little bit uneasy. Even if I'm sympathetic to it as a matter of original constitutional interpretation, the major questions doctrine allows you to get there at a subconstitutional level in a way that I think, gives more latitude for what you're talking about, in terms of taking things out of Congress and giving them to agencies.
So do you think you really needed the major questions doctrine to come out the way they did in West Virginia? I didn't think so. I think you probably needed it in the OSHA case, and I think that was wrongly decided.
From what I understand, and I will readily admit that the Clean Air Act is not my statute. But from what I understand, there were good textualist arguments to get to the same result. And maybe that should have been the way that they went. But, at the same time, I actually thought the OSHA case was right, at least as a matter of statutory text. But the bottom line is, when you're trading off, when you're trying to think in terms of limitations on, sort of outer boundaries, just like Vermont Yankee is sort of an outer boundary on how far we can interpret the text of the APA, major questions doctrine strikes me as a reasonable outer boundary for how far we're willing to allow agencies to push the boundaries of statutory text in terms of, their own power.
Yeah, so I think on the going back to your original question about is it a type of super statute? I do think that there's some different targets, for how to define it, and I was writing my article in response to the kind of Kovacs framing or the Metzger framing, and your article definitely doesn't go there. You don't adopt. I don't view you as adopting this. This is a kind of Sherman Act invitation for courts to innovate. I do think, though, that engaging more with how Congress has legislated, reauthorized all these organic statutes that have different rules than the APA, they've done so consciously. Right. I think Ken Barnett's piece about getting rid of Chevron for OCC preemption decisions, that actually, I agree with you, that actually might build your case that it's a super statute. And I can live with that version of the super statute. It's a framework statute. But I don't get from there to administrative commonwealth. I get from there to more of a Kovacs world of, actually, no. The problem with Katie's approach is, she's like, it's a framework statute, so, in my mind, it's a framework statute, it's really important, the reliance interest, that means we should kind of just leave things where they are, let Congress fix it if they want, and her approach is, that means we should just tear down all the judicial precedent and go back to, I'm not there, but I'm there at the first half of her paper of, it's a framework statute, we should really respect the deals that have been made, and we should kind of just call it a day and let Congress fix it. And so that's my issue, but I think she does, as you mentioned in your article, really do the best job of kind of articulating why it's a statute that should be respected in ways differently than a one-off statute that kind of governs an agency. On the ratchet idea, I think that a lot, I never thought I'd agree with Nick Bagley on stuff. I don't agree with him on anything at all. But I do think he has a point when you deal with rules that are just really, really not consequential. They're implementing statutes that are not consequential, not controversial. They're implementing statutes, they're minor, they're really minor rules. that the way the court has interpreted notice of comment rulemaking, definitely not consistent with what the APA originally was, way too many procedures. And so I actually view it both ways. I think for the big rules, I want Congress to recognize they're big and that the agency might need to do something different. Maybe I don't need to. Maybe Kristin and you have convinced me that just let the doctors play out, and that's actually making me feel a little bit. But that still doesn't answer the minor rules. Like, I don't. And what do agencies do instead? They don't do rules. They don't do notice of comment. They do internal final rules, or they. And I don't like that at all. Like I'd much rather have at least notice, because I think agenda settings where agencies might change their minds. Right. And so I guess that's where I'm at. Is like I'm worried on both ends. I'm worried on the high, but I'm less worried now talking with both of you. But I'm still really worried about the low end. That there's too much procedure required.
So let me make one observation here. And this comes from my empirical work with respect to Treasury. Agencies often aren't very good at identifying which rules are going to be controversial at the outset. I mean, sometimes they are. Sometimes it's really going to be obvious from the get-go. But at least one of the things that I thought was interesting when I was studying Treasury regulations was how often at the outset Treasury would schedule an oral hearing and then cancel it, versus how often they wouldn't schedule an oral hearing initially, and then they would go in and announce one, which I think is a function of them trying to identify and doing not so great a job of it in terms of how much interest there was going to be in the regulation in question. And that's consistent with what I saw, for that matter, when I was at OIRA. That there were some things that they would be surprised that they were getting pushback on things because they just didn't anticipate some constituency having a concern. Agencies they live in their bubbles. They've got their own bubbles, and sometimes they just don't anticipate. They don't know what they don't know. At which point, and this was the whole thing, I think, with Vermont Yankee to some extent, when when the DC Circuit was trying to impose additional procedures on notice and comment rulemaking, the court did observe in Vermont Yankee, I think it was in Vermont Yankee, where they basically said, it's hard to know at the outset exactly which procedures to use. And coming in belatedly as a court and saying you should have used additional procedures intrudes upon agencies too much. So you should stick with what's in the APA. That doesn't mean you can't, interpret the APA's text somewhat capaciously given the open texturedness of some of its terms.
Very good. So let me throw this open now to questions that anyone might have of our panelists.
We've convinced you all.
We've muddled enough. Our clear positions have become very unclear. So.
There you go. You've got one up there. Yeah.
So this is a question for all of you, and this is just to touch on a point that was talked about a lot earlier. If we were to adopt and really commit to like an APA textualism or APA originalism or a interpretive methodology like that, then why shouldn't we also discard the precedents and sort of judicial traditions of certain ones in order, if they were found to be inconsistent with that interpretive methodology?
Well, so if you're going to adopt APA originalism, you got to throw out a lot of stuff, not just circuit court precedent, but Supreme Court precedent too. And I think that would have an enormously destabilizing effect. If you adopt APA textualism, at least in my view with respect to textualism, you still don't have to throw out a lot. And you again avoid that destabilizing effect. The problem is I'm bad at math without a calculator. However many decades now since 1946.
No, I messed that one up too. It's over 75 years.
Okay, so we got over 75 years of judicial interpretation of the APA, but it's been pretty settled for a while. I mean, it's not that there aren't still some open questions, but there's a lot that's been settled since at least the early 1980s. So before a lot of you were born. At which point, there's something to, if you can reconcile it with a particular methodology, even if you think that methodology is right, if you can reconcile it, why mess with it? That's not to say that there aren't necessarily some compromises required. Like I say, textualism's got this whole range, right? And maybe you feel really, really adamantly that the narrow literalist approach to textualism is the way that it should work. But that's the destabilization, I think, is the thing to be concerned about.
Yeah, I think Kristin's right. Laura, if you're an AP originalist or textualist, like 100%, like you don't care at all. Actually, no. No. Stare decisis is part of our law. So if you're an originalist, you've got to kind of work through, how does that play out? I guess that's part of it. I guess so. You don't end up. That's part of the project on AP originalism. And some originalists don't believe in stare decisis, but others do. So you'd have to kind of work through that. The thought I have on textualism versus originalism. There are two very different projects when it comes to the APA. Very different projects. Do the hard work to figure out, if you view the APA as a framework compromise statute that was adopting a lot, or at least ratifying a lot of the common law and other practices that existed at the time, that's a very different project than what does the text say? Does it allow for us to do this or that? Interesting, the stuff Kristin focused on, I don't think AP originalism is going to help much there.
It's because they were focused on
But
formal
on
rulemaking.
deference issues, on the like, you're going to see a lot more on adjudication issues that Emily's kind of gone through.
Yep.
My favorite paper the last 10 years in administrative law. Like you're going to see a lot more of that. I think that's an interesting dynamic. Those are two really different projects, and that's one thing I'm really trying to hammer home in my essay, which will be obvious to most who follow the debate, but probably not as obvious to judges as it should be. That those are two really, really different projects.
I agree with both of them.
Yeah.
No,
Ron Levin, Washington University. When Chris said that I love the RAA, it's because I love it as something to write about and explain why it's so wrong in it. I have two questions, really. One is for John. I have written a paper recently on the major questions doctrine, which I say they have no justification whatsoever. And you can't even justify it as an outer bound unless you've got a good reason for setting the bound, which I claim it does not. But one of the things I noticed when I was writing was that the court relied on the writing of William Eskridge as a justification for it. And Bill says, well, it's better if you have Congress and the agencies and the public all getting together on consensus. It appears to be changing view on that. I wonder if you have any insight into that. The other thing I wanted to throw out, so Chris's point about adhering to long-standing Court of Appeals precedent is one that I fully agree with. I welcome the chance to agree with Chris about something. Because it is somewhat rare. But anyway, he then says, but if you have an open issue, then we should revert to originalism. But he doesn't give any examples of what such an originalist, what an open issue would be. And if one came across, you have a serious question of whether it can be reconciled with the surrounding long-standing Court of Appeals precedents. I mean, you could have a real collision there. And, maybe that would work, but maybe you'd have a real disharmony. And maybe, unless one comes up with a good example and can explain how they would work out, maybe that isn't doing the work for you that you want to.
I've got an example.
Yes?
I don't think that we have given much content to the rule of prejudicial error in the context of rulemaking. In Little Sisters of the Poor, Justice Thomas rejected the open mind standard, which I think most people appreciate is an interpretation of harmless error. But he didn't say what it meant. If you look at Shinseki versus Sanders or other cases interpreting the harmless error rule, they all involve adjudications, not rulemaking. So that strikes me as an open issue.
So the question would be, Does it help us look at originalism with regard to that issue, if that's the...
On that, I have no view.
But others do. That's a good example.
Ron, I'm not sure I understood why I have to defend Bill Eskridge, but okay.
No, you don't.
Who I love, but I don't have to defend him. So go ahead and say that.
So I want to, on the major questions issue, I'd love to see the scholarship, which is 99% critical of the major questions doctrine, and a lot of it's kind of cheap shots about originalism, textualism, and I get it, like fine, I'm there too, but you all are not originalists and textualists. You're writing these articles. You're purposivists, you're pragmatists, you're common law making. And in my mind, in that category, and no one's responded, and it's fine, this seems like perfectly in line with all of those theories of interpreting, of lawmaking, as is consistent with the idea of trying to kind of strike the right balance between legislation and regulation, whether it's elephants and mouse holes, so the majorness using very small ancillary provisions, or whether it's using really old statutes to do things that we know that Congress wouldn't have intended and the current Congress wouldn't do. I think those are really powerful normative arguments that fit very squarely within a purposivist or pragmatist or administrative common law, approach. And I'd love for folks to actually engage with that. So I invite those scholars that instead of falling back and saying we're all textualists now and I don't see it in the text of the APA, well, that's really cute because you're not textualists. And I do think there are some textualists and originalists kind of thinking where you can fit it comfortably within the body of substantive canons that we have today. But I just kind of throw that out there, and I'm not throwing that at Ron because Ron's actually more of a textualist than others. But I do kind of think that's one of the things that's most frustrating about having read, I think now almost 30 papers on the major questions doctrine.
Oh my God.
Is that I've just not seen people intellectually grappling with their own theories of interpretation. Instead, they adopt theories that they don't actually believe in to shoot it down. So.
Noah Rosenblum at NYU. I wanted to pick up Kristin's suggestion to sort of take the historian turn and just ask about the relationship between how what administration has focused on has related to how people interpret the APA. So if I think about the real Schiller story in the back of my mind that, okay, let's be reductive for a minute, but that basically rulemaking is not a major part of the way administration is happening in this country until when, the 1970s, something like that? So then we bring in Florida East Coast and say, hold on, so there is no rulemaking, so formal rulemaking is off the table because it's just not happening as a way that we do administrative governance. Then the Supreme Court comes in and says, oh, by the way, you don't have to do formal rulemaking. So then we get the rise of notice and comment rulemaking and the layering on top of it. But of course, the layering on top of it is happening against the backdrop of a rise of the hard look review standard, which again, according to the standard story, and again, I've got real Schiller in the back of my mind, is an imposition. So if that's right, then at the time the APA is actually enacted, what we think of as the kind of prototypical act of administrative governance is probably some kind of informal adjudication, not rulemaking. We were sort of joking about billion-dollar rules, but there aren't really any billion-dollar rules. The biggest thing the government is doing that affects the economy is procurement, which isn't even covered by the APA. And if a court is going to review the APA, they're going to do it under the super deferential standard. So then fast forward, and it sounds like many of the anxieties that we're talking about how to interpret the APA are actually from a totally different universe, right? The sort of, not just the lost worlds of administrative law of Farber and O'Connell, which we can talk about more later, but like a different kind of governance regime. So, to turn it into a more pointed question, it would be, Chris, as you do the literature survey, I love the breaking it into schools, but what happens when you run that literature survey chronologically? Do we see a change in approaches to the APA based on what is happening in terms of administration? And so, Kristin, for your question about sort of the formal rulemaking piece, does it change how we should think about these standards when we remember that administrative activity is itself evolving and that the kind of court imposition is part of that dialogue? Or do you think the right move is sort of to zoom out and look at it sub specie, ternitas, or whatever, and say, hey, let's make the APA work for a sort of imagined, ideal, typical form of administration as we see it now?
So let me add a couple of things to your chronology there. One being that I think before the 1960s, I suspect, I don't know empirically, but my impression is that most rulemaking that occurred was rate making. And the formal rulemaking with oral evidentiary hearings probably made some sense. You get to the 1960s when Congress expands the kinds of statutes that authorize rulemaking, food and drug, environmental, et cetera. And that's where you get the peanut butter story, right? Where FDA was trying to figure out what percentage of peanut content you needed to have in peanut butter, and spent, a decade and something like 100,000 pages of administrative record trying to decide, if I remember right, between 90% peanut content and 85% peanut content, and it's that kind of story that then I think, plus the academics all saying, in light of these statutes, we need an easier way to do rulemaking than this peanut butter nightmare. That's what prompts Florida East Coast Railway. But then, you've still got then with the rise of informal rulemaking, then you've got courts grappling with, well, if we don't have the administrative record that you produce with formal rulemaking, what do we look at to evaluate whether agency rules are arbitrary and capricious? So put those couple of points into the narrative as well from the chronology.
So I have a historical question. So when I was younger, that was the heyday of Ralph Nader and other people pushing for agencies doing more rules and adjudications, in particular car design. But one person who was important in particular was the chief of staff of the Senate, Commerce Committee, the Magnuson Committee, Mike Perchik, who became the head of the FTC in the Carter administration. And I remember being at a seminar with him in the early 80s. And the person who ran the seminar was a very famous political scientist, Nelson Polsby. And he said, "Mike, you goofed up." That's not the word he used. What explains it? And he said, "I forgot about Congress." So he didn't talk about the court. Because what had happened is he went over to the FTC and he issued a rulemaking on funeral directors and on the thing that put the stickers in the back window of used cars, right? Two industries that have people in every single congressional district. The blowback was enormous, and it crippled the agency for half a decade. So now nothing to do about courts. It's just that these turned out to be really controversial. It underscores what Kristin said. He didn't see it coming. He totally did. He thought, since I come from Congress, I know Congress. Well, what happened in 1980, 81, was different. Reagan got elected. Essentially the conservative coalition was back in essentially majority position. So it was a different Congress, and Mike didn't see it. So I'm saying that's an interesting feature about rulemaking, and there were many different adjustments. And then soon after, the Chatter ruling came down. So the practice that had been in place for Congress to short circuit some of the rulemakings was gone. And I think that may have played an important role. I don't know which role it's played subsequently, but it might be worth some historical revisiting. Because I think it's pretty important that, Congress is kind of formally removed. Now, I agree that there still are, legislative vetoes de facto, but they don't play the same role anymore that they used to. And that might have been important in some historical period, for exactly this period when rulemakings were becoming more common. So.
Kristin?
Yeah, I love the question. I think, and I see it play out with the nationwide injunction universal vacature debates right now, where you have kind of like ships crossing in this, you've got the Sambray, this isn't how, when the APA was passed, they weren't really thinking about rules, they were thinking about adjudication. That was and set aside. And so I think, I do think there's a matter of kind of like translation that has to go on to figure out the new approaches. And that's why, from a statutory stare decisis perspective, I find comfort, when it comes to statutory stare decisis, it doesn't matter if they use a different methodology. That's not a factor the court looks at. And just kind of setting it now, so we're gonna kind of lock in. The court's done a lot of crazy, interpretive moves over the last few decades. We're gonna lock in what we have now because that's our law. But going forward, the message is, if we want to innovate, don't come to the courts, to innovate administrative law. Go to go to Congress or go to the agencies where there's a lot of flexibility for them to also innovate. So that doesn't answer your question, but I definitely agree. I don't think I can do the chronology in this piece, but I definitely think it is an interesting one. I mean, one thing I will say that was interesting, I wanted to tell the story. Scott and I told Scott, I was like, I want to tell the story as it started as this, it turned to this, it turned to this, it turned to this. And it was this nice, clean, beautiful story. It just turns out it's not true. Like all four of those theories are alive today. In fact, there are judges that adopt all four in different contexts, and maybe that's okay under John's, under your view. I think that might be okay because it's different provisions, or might not that is okay, but it could be okay because you're looking at different provisions where you might allow for common law making, others that don't. But it didn't have that clean chronological story I wanted to tell. That would have been a much easier paper to write.
Well, my theory has always been that moderation is best when the moderator speaks least. That is a very easy thing to do when we have 3 such engaging papers and 3 such engaged speakers as we have just had. So let me thank all 3 of them for their work.